annual report on the judicial functions and court performance is being released this morning by the heads of court led by Chief Justice Mogoeng. The report examines the performance and targets set for courts across the country. The judiciary has in recent months come under fire by some political parties who've alleged that courts are not independent and lack accountability. We cross live to the release of the report where Chief Justice Mogoeng is on the podium set to deliver the keynote address.
Justices of the Supreme Court of Appeal, judges presidents, deputy judges presidents, and judges, regional court presidents, chief magistrates and senior magistrates, other judicial colleagues present, Advocate Mpaga SC on behalf of the General Counsel of Bar Council, Advocate Shamila Batoi, the head of the Prosecuting Authority of our country, my spiritual parents, led by Pastor Ibitayo and Pastor Mrs. Ibitayo, members of the Judicial Service Commission, members of the Council of the South African Judicial Education Institute, colleagues in the legal fraternity, the Secretary General of the Office of the Chief Justice, Ms. Mmesi Josengwe, the Director General of the Department of Justice and Constitutional Development, Mr. Madonsela, other Directors Generals that I may not have seen, members of the Audit and Risk Committee of the Office of the Chief Justice, colleagues in the National Efficiency Enhancement Committee, representatives of other state institutions, members of the media, fellow South Africans, I greet you this morning. We cherish and treasure the privilege bestowed upon us to be bearers of the constitutional mandate, to be final arbiters in all legal disputes in this country. And we appreciate deeply the opportunity to present a somewhat brief report on essentially where we come from, where we are, where we need to be, and how. I think it is necessary to give some background to our approach to our accounting responsibilities because there's been a bit of misunderstanding. It wasn't a thumb suck. We reflected on how other jurisdictions go about accounting for the execution of their constitutional mandates. And some of the countries we look to are Singapore and Malaysia, but we paid particular attention to how the United States of America, the United Kingdom, Ireland, Kenya, and Uganda does it, because there are a lot of similarities in relation to their particular mandate and ours and how they are expected to execute it. So we decided to pay particular attention on ensuring that, unlike before, there is a somewhat well-coordinated structure in place. Because in the past, you would have a Chief Justice there and judges presidents going about their business, only responding to an invitation by the Chief Justice to have a meeting together to chart the way forward to the judiciary as a matter of courtesy. There was nothing either in the Constitution or in any law that imposed a semblance of an obligation on them to respond positively to a call to come together and deal with issues that required attention from the judiciary. So it is this and other major issues that we need to focus on. We didn't have any judicial case management to write home about. We didn't have norms and standards to write home about. We didn't have any well-organized machinery at a national, provincial, regional, and district level that brings together all the critical role players in the justice system together. We didn't have any form of mediation. We didn't have much of what is required for the court system to function as efficiently as the people of South Africa expect of it too. So I know that some are concerned about the finer details. Instead of saying, at long last, here is a vehicle, it has wheels and a steering wheel, and there is a clear direction in relation to where it is going and how it hopes to get there. People are worried more about, but what about the condition of the seat? What about the dashboard? When are you going to fix the cracks on the dashboard? We're very much alive because we operate in this space. To what is it that cries out for fundamental change? And we will get to the nitty-gritties that people seem to be concerned about in due course. Some of our people are saying, your audit reports do not tell us when did each court receive which case, when did that case get enrolled, and how long did it take you to move from enrollment to the end? We very deliberately decided to focus only on the commencement of the trial or the hearing all the way through to reserving or delivering judgment, and if a judgment is reserved, how long then does it or did it take those that delayed to move from the reserved judgment up to finality? And you may ask, but it's important for the purpose of measuring performance to know when the case got into the court system and how long it moved from there to the enrollment. It is true. But the priority is to focus on matters that fall squarely on the shoulders of judicial officers. In other words, matters that judges have the unmistakable and the unquestionable sole responsibility to determine the pace at which they are going to move. But after enrollment, you still have judicial officers and all sorts of other people, including witnesses and the police in case of criminal cases to contend with. So you are not in a position to really blame the judicial officers for not having done as well as they are expected to in relation to that period or that stage, because there are many other players involved. That is why we have established the National Efficiency Enhancement Committee and the Provincial Efficiency Enhancement Committee. That brings us together as key role players in the broader justice system. Deal with issues that cause delay that are not exclusively under the control of the judiciary. So for the past 8 years or so, we've been very deliberate and intentional in ensuring that whatever is necessary to answer the cry of the South African public about the delays in the system is done. The groundwork, the fundamentals that are necessary to move us to that point are in place to help us move with deliberate speed. We could have included, for instance, the number of postponements for each and every case. It's not feasible. It's not only a very laborious exercise, it's also very costly, too costly for the limited resources that, at our command, particularly because we truly are thinly staffed administratively. So what we have decided to do as one of the major issues or developments to be factored in the way we do things is to modernize courts. And that, of course, depends on funding. I may have mentioned it to some that I was approached by somebody to offer in 600 million rand so that we can modernize. But I know that person, I know that institution, I rejected it with the necessary contempt, because that's how capture happens. We don't want to be funded in the middle of the night, however people may posture as benevolent givers of assistance. So we need, and we have done a lot of work to develop a court automatization system based on what we have seen in the US, in China, and other jurisdictions. Funding has been the major frustration. But Judge President Mlambo and other colleagues in our Modernization Committee would tell you, good progress has been made. case lines, a system now that deals with case lines is in place. A pilot project is underway in the Gauteng courts under the supervision of Judge President Mlambo. So we tend to be compared to jurisdictions that have been well organized for well over 100 years, and I think unfairly so, and selectively as well, because we say without any fear of contradiction that if you compare us with even some of these jurisdictions in all respect, in our 25 years of existence, many of them still have a bit to learn from us. We say it with all sense of humility. Broadly speaking, in relation to the focus on matters that are of great significance, we've made a lot of progress in the limited period that we have had to bring about change. Now, I think we indicated in the past what the court modernization program is going to entail. It's in the report. It's all about e-filing. It's all about capturing that data that our people need for the purpose of judging our performance. We're very much alive to that. We want to develop a system that will enable us, through our smartphones and iPads, wheresoever we may be, to be able to tell what is happening in any court, anywhere in the country, and to tell immediately whether there has been a postponement and what the reason for the postponement is, so that when intervention is speedily required, we may do so. So we are building systems with norms and standards in place, judicial case management and court annex mediation embraced, and automatization being at an admirable stage under the circumstances. We are satisfied that a lot of good fruit is indeed being yielded by our efforts. Ask any practicing lawyers whether in our higher courts where these innovative measures have been introduced, performance is reducing or declining. I believe that they will tell you that there has been a lot of progress, because they used to wait much longer to get a date, even for years, to get a date for the hearing. Because of the systems that we have introduced, it's no longer so. The judiciary is in the process of developing a strategic plan for the years to come, as the Judge President has indicated. And the 2018-2019 annual report contains descriptions and explanations for the indicators to assist those assessing the performance information. I must just say, because it has been raised, we can't use the appeals to measure the performance of judges. I say it because people say, to get a good sense of whether judges are doing well, and magistrates, you've got to track how many of his or her judgments have been appealed against. I don't think it helps. People appeal either because they have resources or they don't, and others appeal because they are justifiably or unjustifiably led to believe that they have a strong case. You also cannot use as a yardstick for performance whether the appeal was successful or unsuccessful. We, as the Constitutional Court, on a regular basis, set aside judgments of the second highest court in the land, the Supreme Court of Appeal. Not because there is anything wrong about the quality of the judgments that our colleagues have delivered, and the same applies to all other courts. Most of the time, it is a difference of understanding of the issues of importance to us in relation to the quality of judgments or performance, is whether or not there is a sound appreciation of the legal principles, and whether the approach is that can be expected of a competent judicial officer. But to say whether an appeal goes this way or that way would be highly misleading. After all, even the judges of the Constitutional Court can have at times, I think there's a record of about 5 judgments. Who is competent, who is incompetent then among us. So the appeals, or the noting of the appeals and their outcomes would be a less than satisfactory yardstick for judging the performance of the judiciary. My sister, Advocate Batoya, and your colleagues, I hope you won't see this as an attack, because it is not. But there is a problem that needs to be corrected happily. The chair and members of the portfolio committee are here, the public is here. And it relates to how the National Prosecuting Authority assesses its performance. I think it is wrong to use the conviction rate as the test for determining whether the prosecuting authority lives up to the expectations that flow from its constitutional mandate or not. Prosecutors don't convict anybody. How then do you credit them or disadvantage them because there have not been convictions? How do you hold them responsible for what magistrates and judges do? You will never be able to tell whether prosecutors do what they are expected to do for as long as you use how many convictions are there, how many acquittals are there as a yardstick for determining whether they are doing what is required of them. The responsibility of the prosecutors is no different from the responsibility of members of the bar or of the attorney's profession. Theirs is to present their cases to the best of their ability and leave the rest to the judicial officers to do what needs to be done. So another yardstick must be determined. Otherwise, even in circumstances where, as they know, they are under a legal obligation to make available information that could lead to the legitimate acquittal of an accused person, because of this pressure, they will have to insist on conviction, even if it is not in the interest of justice to do so. This thing must be revisited, it must be done correctly, and it doesn't matter what other nations are doing about it. It's a logical thing, and we've got to confront it, interrogate it, and say why we believe it's a reliable yardstick for determining the performance of the prosecuting authority. I summarize court performance as follows. During the period under review, the superior courts managed to perform at 70%. The following targets were not met. A percentage of constitutional court cases finalized, 76% against our target of 80%. Percentage of competition appeal court cases finalized, 57% against the target of 90%. And a number of criminal cases on high court roll for more than 12 months is significant for understandable reasons. The challenges experienced by the judiciary in this regard have been exacerbated by the ever-increasing workload on these courts, notwithstanding the fact that the judicial capacity has never been increased. The 17th Constitution Amendment Act has really disadvantaged the Constitutional Court and undermined its capacity to deliver as expected. And here is the reason. We have no possibility, unlike some other comparable courts, and even unlike the Supreme Court of Appeal, of sitting in panels. It's either all 11 of us must sit or 8. And even then, every judgment that is written, every application that is processed, each and every one of us must bring his or her mind to bear on it. It takes too long, embarrassingly long, particularly in relation to complex matters and matters that are just too involved. So much so that some of us have been wondering whether the time has perhaps not come to increase the number of judges of the Constitutional Court. Some people say, no, it will never be the same. It will lose something. Or to merge the Constitutional Court with the Supreme Court of Appeal. After all, the judges of these two courts earn the same salary. Whatever the case may be, it looks like something radical or fundamental needs to be done to inject functionality and more efficiency in the operations of the Constitutional Court. What I have discovered with my colleagues in Germany is that they draw judges from the likes of the Supreme Court of Appeal, the High Court, and senior officials from the National Prosecuting Authority to process matters for them and even be deeply involved in the crafting of judgments and orders. What happens here is that we have the benefit of clerks, most of whom come straight from the university with very limited, if any, practical experience to be of assistance where it matters the most. They are doing a good job, but not up to the level where assistance is critically required, and that is in relation to the judgments. The Supreme Court of Appeal, I alluded to it, it has done, I think, better than any other court, considering the workload. And it is the possibility to have panels in place for the determination of the issues that I believe has greatly enhanced the possibility of finalizing cases speedily. Our high courts have really done well under extremely challenging circumstances. The statistics are there. I mean, they had a total of 145,127 civil cases, and finalized 114,650, and 13,140 criminal cases, and finalized 10,666. So I think there's good progress. We must just focus on what else is required of this court to be able to do much better than it has. The specialist courts have also done well. I mean, the Labor Appeal Court, for instance, had 5,915 cases, the Labor Court and the Labor Appeal Court, and they've been able to finalize 3,756 cases, and more judicial capacity is, of course, required there. The Competition Appeal Court had 7 cases, it's been able to finalize 4. And I didn't mention the statistics of the Supreme Court of Appeal. They finalized 214 of the 231 during this period of reporting. And additional to that, they had to contend with 1,062 applications, which were finalized out of 1,095. The Electoral Court has also lived up to its track record and done justice to its mandate of expeditiously finalizing cases that are referred to it, given their sensitivity and the speed with which circumstances almost always dictate they must be finalized. Reserve judgments, we've got a mechanism set out in the norms and standards through which they must be dealt with, and there is a report always with every head of court that relates to these matters. The norms and standards in the Judicial Code of Conduct regulates what is it that may have to be done depending on the progress or lack thereof in relation to these matters. So we also have, and maybe I must read it, as part of accountability and in an effort to be transparent, the head of courts have taken a decision that a reserve judgment report containing a list of those judgments outstanding for 6 months or longer will be placed on the OCJ website. Any request for further information, such as the disclosure of information on the list of reserve judgments for individual judges or judgments outstanding for less than 6 months, must be referred to the head of the court concerned. Another new development in this report is the inclusion of key performance indicators for the regional courts and the district courts. I must thank my colleagues in the regional courts and the district courts for having taken it upon themselves to refine the performance, the key performance indicators so that they are in sync with where we need to go. We have not been able to attach the performance report because everybody knows that the magistracy have got a virtually impossible task on their shoulders that seems to defy the possibility of speedily coming up with a report that speaks to how they have been performing over the years. But it is something we are working on, which we hope to to share with you as part and parcel of this annual reporting. The South African Judicial Education Council, SAJE, has facilitated a total of 142 judicial education training courses, and covered a total of 3,068 delegates in the period under review. The training conducted including court annex mediation, case management, and skills relating to the management of children's court, criminal court, family court, civil court, and they also extended to competition law, cybercrime, maritime law, judicial ethics, as well as environmental crimes. And SAJE has also produced 2 monographs on judicial education. The stress on judicial officers as a result of the traumatizing cases that they have to deal with, rape cases, gruesome murders, and some extremely challenging divorce matters involving children, as well as some of these gratuitous attacks that people just take the liberty to level at the judiciary without any substantiation, have necessitated the establishment of a bespoke judicial wellness program. We have developed something that we are reflecting on. We've been in consultation with one of the top clinical psychologists to guide us in relation to how exactly to manage this. We have drawn from countries like Singapore and Australia, who have moved miles ahead of us in this regard, so that because this trauma and these challenges are given birth to by the work environment, it should not be left to the individual judicial officer to fend for himself or for herself when challenges come. And to be more inclusive, we are thinking of having this housed under the auspices of the South African Judicial Education Institute for as long as the Office of the Chief Justice does not serve the magistracy. We're still waiting for that process. It's work in process. So we're working on that. It's at an advanced stage. We can only hope that resources will be made available so that you don't have a situation where colleagues crumble under stress at work in circumstances where it was foreseeable and something could have been done about it. One of our priorities is, of course, the introduction of court annex mediation. We had a fully blown training program necessitated by a 90-year-old judge of the 9th Second Appeal Court, I think they call it, Justice Warren. He is sharp. He is loaded with experience. He doesn't use any walking stick. And we had the privilege of learning from him, not only in relation to how to apply a win-win court annex mediation program, but also how to come to grips with the fundamentals of judicial case management so that you can benefit optimally from it. A number of colleagues have been trained. We are about to send, or have already sent, just President Mlambo will tell, about 7 or 9 of our colleagues at great expense to attend a conference in the US so that they can see for themselves how these things are done. I raise it deliberately because every time judges travel, it's like it's something wrong. It's like it's corrupt. We're very responsible people. And we are not tourists. We want to learn more firsthand, like all other arms of the state do as and when it becomes necessary to do so. We are on the verge of appointing a highly skilled mediator to oversee the implementation of this program and the training of the trainers. I must say, we have a pilot project running already, both in the 2 Gauteng High Courts and the Magistrates Court, under the supervision of Judge President Mlambo and his deputies, Deputy Judge President Ledwaba and Mojapelo. Now, we have also decided that only trial-ready matters will be set down, and that would, of course, be after a proper pre-trial conference would have been held. We involving more and more judicial officers in the management of pre-trial conferences because of the disastrous pre-trial conferences that used to be held in the past. Just to cite an example, when I was judge president, I came across a pre-trial conference minute where one lawyer had a pre-trial conference with himself, and he was asking himself questions and answering, and produced that for the purpose of having the matter enrolled. So because of the many absurdities that have a tendency to delay, we've decided to assume the responsibility of ensuring that this thing achieves the desired purpose. At long last, we have the Uniform Rules of Court amended, an initiative of the judiciary, which was also, produced a draft actually, that culminated in what we have right now, to facilitate the proper implementation of judicial case management and court-annexed mediation. It took too long, which takes me back, Honorable Magwanishe and Honorable Deputy Minister, Honorable Deputy Speaker, and Honorable Deputy Chair of the NCOP. We know, that legislative responsibilities rest on Parliament, no contest. But the very reason that the rule-making process can never kick off without the involvement, the critical involvement of judicial officers, tells a story that you would do well to go back to where the situation was in 1965, when the Uniform Rules of Court were drafted. It was the judiciary at the time that had the responsibility to develop and finalize their own rules because they know what they need. The insistence on having an act as currently structured that gives the responsibility to draft rules on the executive defies the very purpose of ensuring that we change systems as speedily as is necessary so that the court can function with greater efficiency. We have to wait for years, sometimes even after the rules have been finalized, for the minister to sign. We are not looking for power. We are looking for a responsibility that will facilitate speedy and quality service to those who consume our services, the South African public. So please reconsider. Now, the Judicial Service Commission was established for the reasons you know well. Transformation of the judiciary, but also to bear the responsibility to deal with cases of misconduct against those of us believed to have been involved in acts of misconduct, rightly or wrongly. And a point needs to be made. The judiciary has never shied away from holding their own to account, never. You may raise concerns about the speed, but nobody can legitimately say that when there were allegations leveled against the judicial officer, we kept on digging and diving as if we want to cover up for one of our own. Never. The result is most of the cases of misconduct referred to the Judicial Service Commission have been finalized. We only have a few that have been staring us in the face for a very long time, only because there was litigation. And I've got to deal with this issue because it keeps on coming. If there is something that would really be a blight on the record of the judiciary, it is their failure to move with speed in relation to certain cases of misconduct. There's no blight. Cases of Judge President Hlophe, cases of Judge Motata, cases of Judges Mavundla, Preller, Poswa and Webster took long for good reason. There was litigation involved. And the notion that when a judge wants to litigate, somehow the JSC or the Chief Justice has the power to say, no, forget about the Constitution. When it says anybody has the right to have his or her dispute heard by a forum or a court of law and be decided in terms of the law, it does not apply to judges. It's a fallacy. It would be an illegality for the Judicial Service Commission or the Chief Justice to try to prevent any judge or any magistrate who believe that there is wrongdoing in the process of preferring charges of misconduct against them or processing those charges of misconduct against them to challenge. They are entitled to challenge for as long as they want to. You would recall that even judges of the Constitutional Court, who were supposed to be witnesses, challenged and delayed the matter further. So how do you blame the Judicial Service Commission or the Chief Justice? We have got to be blamed and criticized for everything that we were lawfully able to do but failed to do. Having said that, we hope to finalize the Mutata matter this week. One thing or another has been coming whenever we try to finalize this matter. I hope nothing will come out. We hope to dispose of the Preller, Mavundla, and Poswa matter this week. The one of Justice Webster is a bit of a challenge because of the medical issues involved. I can't say how long it will take to resolve the Judge President Hlape one. There seems to be a number of challenges there, funding-related challenges. So, criticism that assumes that we could have but failed to expedite this process can in the very least only be a consequence of ignorance or frustration. Now, there have been allegations of corruption against us, against the judiciary. And some people believe that it was just a matter of either the Judicial Service Commission or the Chief Justice are approaching the banks of the colleagues involved and say, bring their bank statements, let me see whether the money that Twitter says entered their bank accounts did enter. It would be illegal. We don't have the power to peer into the bank account of our colleagues. That is why, in line with what the law allows us to do, we, as the judiciary, instructed the Secretary General of the Office of the Chief Justice to write a letter to the National Commissioner of Police to use his lawful powers to investigate this matter, including locating the faces behind allegations that the judiciary or certain members of the judiciary is corrupt. And we've received a response. The National Commissioner says he has directed the Hawks to deal with the matter. I know that Mr. Rahube presented a document to me at the press conference we had on the 13th of this month. I also know, and I was shocked to see a heading on a poster coming here from Mahikeng on Wednesday. Everywhere almost. SA judges misled to facilitate de facto money laundering, UK claim. That is based on what Mr. Rahube said and on what Mr. Lewis said. Mr. Lewis is a farmer from the UK. He says it himself that he's not a lawyer. He, among other things, approached me to say I must now give authority to Lord Hale to investigate judges of the KwaZulu-Natal Division of the High Court and of the Supreme Court of Appeal. I must subject judges to some Majitsky, I think something like Majitsky Act of the United Kingdom. Please, any well-meaning South African read the document of Mr. Rahube, read the document of Mr. Lewis, I am shocked beyond description that any newspaper could find it acceptable to publish a story, a baseless article, under such an extremely damaging heading. Because those who did not read the article to see its emptiness for what it is, and have just seen the posters, went home saying, there they go again. Now they've moved from sheer corruption to the facilitation of money laundering. Any South African who cares about our constitutional democracy, any South African who cares about the future of our children, we say to you, we are not perfect people. We are not a perfect institution. And we ought not to be immune from legitimate criticism. But this gratuitous criticism, as if there is a campaign to delegitimize the judiciary, so that when they make orders against you, you can have the opportunity to say, this is an order by corrupt people. This is an order by facilitators of money laundering. How can I be expected to obey this order? It took this institution, we say it with all sense of humility, to intervene when it matters the most. And I urge every South African who cares about this country and its future to make it his or her business to wake up and deliberately confront any baseless accusation of corruption in the judiciary. What did we say? We said anybody with the evidence must come, so that if there are rotten apples in our midst, they can be kicked out rather than spoil the reputation that we have worked so hard to build as the judiciary. What do we see? We see Mr. Lewis, who is unhappy because the way the court interpreted the evidence is not satisfactory to him. He is not saying any particular judge is corrupt. He is not. We have Mr. Rahube. What does he say? He says he suspects that the documentation presented for the adjudication of his case may possibly be tampered with by the registrar or other officials of the High Court. We were asking for evidence of corruption against the judges. Where is the evidence? So if anybody has evidence, all we are saying is we are begging you to present it, and feel free to even publish it before you give it to us. That's how confident we are that we don't cover up for the corrupt. Sexual offenses or gender-based violence cases require an integrated approach by all key stakeholders. And what follows are some of the measures that could alleviate the problem. I think we need an awareness campaign, an informed awareness campaign to the general public that says, we know that there's been a lot of humiliation, there's been a lot of discouragement that came with reporting these kind of cases. These are the measures, the practical steps we have taken to alleviate that humiliation or that encouragement. That public awareness campaign must also include how to report